Good morning. This is the second case on our docket this morning. It's number 122400, Marcus versus Swanson, and a cross appeal versus Marcus. Counsel, this case is set for oral argument today. My name is Steve Hill. It's my honor to be the presiding judge of this panel. I am very pleased to say that I am associated with Judge Gordon Atchison, who on my camera is to my right, and Judge Sarah Warner, who is to my left. All three of us are experienced judges on the Court of Appeals, and we are anxious to hear from you today. We have read your briefs, and each side will have 15 minutes. We have received a memorandum of law from our research staff concerning that case, concerning this case, and I think we might have some questions for you. So be prepared for that. I would ask counsel for the appellant to enter his appearance.
My name is Frankie Forbes, and I represent the appellant, Dr. Eric Swanson.
Mr. Forbes, is it Forbes? Are you on the brief?
I am not on the brief, Your Honor, but I filed my entry of appearance to argue before you today.
Okay. I may not have seen that. And are you wanting time for rebuttal?
Yes, Your Honor, 3 minutes.
I had trouble there.
3 minutes, Your Honor.
3 minutes, okay. Now, counsel, I might tell both of you, we have experienced some technical difficulties today, and the recording has gone off a couple of times. If that happens, I will interrupt you and we'll wait until the recording comes back on before we proceed, unless we get tired of it, and then we'll just see like just then. So we'll wait just a second to see the recording back on. We're having a thunderstorm right now in Topeka. Very good. Now, counsel, let's hear from the appellee's counsel.
Good morning, Your Honor. Matt Bartle for the appellee, Alicia Marcus.
All right. Very good. Now, we'll proceed with the argument. Mr. Forbes, tell us, how did the trial court get this wrong?
Well, thank you, Your Honor. We believe the trial court got this wrong because they reweighed the evidence in this case after it was submitted to a jury post-verdict. As Kansas courts are very clear, the standard of review in a post-verdict motion for judgment as a matter of law is that all reasonable inferences and facts must be construed in favor of the non-moving party, which in this case would be Dr. Swanson. We do not believe that the district court did that in this case, which is somewhat interesting given that the court's ruling on its summary judgment motion prior to going to trial, we believe set forth the correct standard that should have governed throughout. And in the summary judgment ruling, the district court clearly understood that the jury's role was to measure the extent of the damages in this case, not to determine the existence of the damages. And they said at the summary judgment stage that damages were found according to the Rock Hill standard, that Dr. Swanson's own observations were relevant of proof of harm to his reputation for damages in Kansas, so long as they raised a reasonable inference that damage was caused by Ms. Marcus's statement. And the court went on to say that this is the burden that Dr. Swanson must meet at trial, and that his deposition testimony that his reputation was harmed directly by Mrs. Marcus's Yelp review was sufficient to preclude summary judgment. That was found on volume 1, page 124 of the record. After 3 days of trial, the jury did find that Mrs. Marcus's Yelp review caused damage to Dr. Swanson's reputation. That was their finding at the jury, and then they awarded $15,000 of damage for that reputation standard. In comparison, this case is very similar to the Rock Hill case, but in that case, their jury found a lot more damage to the reputation of the anesthesiologist at issue in that case. They found $940,000 worth of damages as opposed to the $15,000 found in this matter. So in our review, there are similarities. For example, there were patients that came to Dr. Swanson, his existing patients, that saw the falsehoods that were posted on Yelp and said, well, that could be very damaging to your practice. And had I not known you and had experience with you prior to, that may have impacted my ability or my decision to come to you in the first place. Dr. Swanson is a plastic surgeon that relies upon advertising and marketing for his practice. And he's worked very hard to establish his reputation. And so in our view, the district court replaced or reweighed the evidence post-verdict.
So are you basically arguing that the judge substituted judgment for the jury?
Yes. Yes.
And how did it go about doing that?
What it did, in starting on page 178 of record 1 on the judgment of the matter of law, the district court kind of introduces its reweighing of the evidence by saying that the testimony about harm to Dr. Swanson's reputation at trial came from 2 witnesses, Dr. Swanson and a patient, Nicole Neufeld-Hart. And then it goes into basically picking apart the evidence that each of them provided at the district court. Starting with Dr. Swanson, the first...
do you disagree that those are the sources of the evidence, those 2 witnesses?
No, I do not disagree with that. Those are the 2 sources of the evidence of the damage to the reputation. That's correct.
I mean, what were the quote observations of Dr. Swanson that supported damage to his reputation? I mean, specifically.
Yeah, under the category of damages, I think, was established by Ali versus Douglas Cable Communications. There were 3 categories. Standard in the community of whether or not there was a drop in reputation, were persons deterred from associating with Dr. Swanson, and then finally did his profession suffered. And at the district court level, there was evidence produced by both Dr. Swanson and the patient that all 3 of those categories were present.
Well, that's what I'm asking. What is that evidence?
Yes. So his damage in the community was lowered. I don't think can be any more clear than his Yelp review rating went from a perfect 5-star rating to a 3.5-star rating. That's a pretty objective measure of your reputation on the online community of the patients that are looking to see you.
How many people were affected by that?
That is unknown as far as that's not something that it was able to be determined of who has reach when that audience was that broad.
I mean, it seems to me that's a problem. I mean, if it were 10 people, it's one measure of damages. If it were 10,000, it's some different amount, isn't it?
It is, and since it's undetermined, that's the problem with defamation. Once this is out in the public of who all is able to obtain it. The Rock Hill case basically identified this as an issue and said it's impossible for the plaintiff, the victim in this situation, to be able to ascertain who saw it and who didn't, and how are they able to respond to that. But I don't think there is any disagreement that the reach of the internet is far and wide. What's interesting about these cases, they go all the way back to the 1970s, and then it was a little bit easier because you're looking at newspaper circulations and how many people have bought these newspapers. New York Times v. Sullivan, the Gertz case, United States Supreme Court also dealt with this. Gobin, the triumphant, or the three cases in Gobin had to do with a newspaper out in Dodge City. We're not in that time anymore. We're now in the age of the amateur, where anybody with a keyboard can.
Isn't that the law we're stuck with? I mean, we're stuck with law that's 40 years old and doesn't necessarily account very well for the internet.
I don't think we're necessarily stuck with it, but I think there is an argument to be made that the law may need to evolve into where the current standards are and the current realities of who can publish and who can defame. I don't think, though, that the standards set forth in Gertz and the other U.S. Supreme Court cases and the Kansas Supreme Court cases on defamation have changed, where there is definitely something to be said for the integrity and preserving the reputation of an individual. And that reputation may vary based upon the individual. So some person could say something that could be a falsehood that one person could consider that is in a profession that relies on foot traffic that would be very damaging, versus someone else that's not in that same profession may not cause the same level of damages. That's the difficulty on these defamation cases.
Well, and I appreciate it's difficult. Also, I mean, as I understand the evidence at trial, Dr. Swanson could not point to any diminution in his business. I mean, basically, he was working to capacity before and after. He had as many patients as he could handle, essentially.
Right. I don't believe that the evidence stated that he was at capacity. What the evidence showed is that he did not have a drop in either patient volume or patient revenue. So he was not able to demonstrate pecuniary losses as a result of the defamation. That doesn't mean that his reputation wasn't damaged. And sometimes, especially in a business that relies upon the good word of mouth in order to get referrals and to get people to come see you, you may not see the damages for years down the road when you're no longer able to schedule out your patients to see. And we think that the jury understood that from the testimony and was able to determine that whether or not a drop in the Yelp rating from 5 to 3.5 stars harmed his reputation. The other thing that the review did is it moved 15 5-star reviews that had very long, nice things about him to a secondary level to where that's not easily seen. So what would happen is a person would click on the reviews and they would get 3 reviews, including the falsehoods that were perpetuated by Ms.
Well, apart from the effect of the Yelp review on potential patients, putting that aside for the moment, what were the other indicia of damages to Dr. Swanson's reputation?
Yes, the persons were deterred from associating with Dr. Swanson, and that was in the record with evidence from the patient, Ms. Hart Neufeld. She felt that the review was inflammatory, incredibly disparaging, alarming, and troubling. That's in the record 4, pages 7 to 10, 25, and 27. She believed that it was incredibly damaging to Dr. Swanson's professional reputation. She was so concerned about the impact, she felt compelled to have a positive review posted. She did that on her own initiative, hoping to mitigate the reputational injury that she would suffer. But her review was also put into the unrecommended status, not on the top level, but she saw him anyway.
I mean, that's her opinion. Is that evidence of damage to Dr. Swanson's reputation? I mean, she said she was unaffected by it. I'm not sure I see how that, her testimony specifically, other than her opinion about what she considered the review to be, translated to a loss of reputation on Dr. Swanson's part. And I mean, I appreciate that in the age of the internet, this is very difficult, but to be honest, I am sort of struggling with what the tangible evidence of damage to reputation was, and it's a squishy area. I agree. What what is the best argument here for some demonstration of actual damage?
Yeah, and I think it's also important to note that there were other patients that had also mentioned this to Dr. Swanson, which in the order, the court said there wasn't that, but it's found in the record, volume 2 on page 202, and that was never challenged at the district court level. And besides the Yelp review that went from 5 to 3.5 and what the patient had said, and the patient also said that she would have been inclined not to use him, but she had had previous experience and knew that he was a good physician. And this goes right to the issue in Rock Hill that it's very hard to be able for a defamation plaintiff to be able to determine what they don't know. Who are the people that never went to them to begin with? But I think it's a reasonable jury inference after hearing the testimony that the reputation was damaged. The other damages that were talked about at the trial also included the hundreds of hours that Dr. Swanson spent trying to remove or to mitigate the damage from the negative review. In Getz, they say the first remedy for a defamation plaintiff is self-help to try to fix it and correct the falsehood. And in that case, that was unsuccessful to do so because the review would not be taken down. And
Counsel, let me interrupt you you've got about 30 seconds left. So if you'd like to sum up, or you'll be going into your rebuttal time.
Okay. Yeah, to sum up, he also hired an outside consultant, which the district court dismissed because they didn't allow an outside consultant to testify at trial. That's in record 2, page 200 and 202, but there was no evidence at trial to demonstrate that's even the same expert or there wasn't other advice given for mitigation efforts to deal with Yelp. The court was also very dismissive of employing staff to assist in those efforts, and they criticized Dr. Swanson for not introducing evidence of actual damage or to quantify the damage. And Getz says you do not have to quantify that damage in order to show it. You don't have to quantify it. But Rock Hill said that it was a reasonable jury inference that a lucrative industry, such as an anesthesiologist in Rock Hill or a plastic surgeon in this case, would suffer damages had they had to take time out of their busy practice to deal with this. And I'll yield the balance of my time.
All right. Thank you, counsel. You still have your rebuttal time.
Thank you.
All right. Counsel, we'll hear from the appellant, Mr. Bartle.
Good morning.
Appellee. I'm sorry.
Good morning. May it please the court. Not only was there an absence of proof of reputational harm, there was actually plenty of proof that Dr. Swanson's reputation was not harmed. His own lawyer said so more than once. In describing Dr. Swanson's strong reputation during his closing argument, counsel said this: "Who did Lester Holt with ABC News in New York come and talk to? Dr. Swanson, because he's that good. His reputation is that good. Why do you think he hasn't been hurt by her Yelp review?" Now, this was not just a one-off slip of the tongue. Counsel also said this in opening statement: "With such a good reputation, this one negative Yelp review hasn't killed his business. You know, his practices remain the same." That was later disproven. His practice actually improved after the review.
But ordinarily, we give tremendous deference to juries, especially in civil cases, deciding matters of liability and damages. Why should this case be any different? Jury
determinations, for sure, under the law over the years, for years and years and years, have been given enormous discretion. But there is a rule on our books that allow judges to look and determine whether there were facts from which a jury could make a reasonable inference. The jury sent the judge a question, Your Honor, and asked if there was any way they could order that the post be taken down. And of course, the response was that no, they had to deal with the jury instruction. This jury was really struggling because there was no proof of reputational harm. And then you had these comments by counsel saying as much, and the jury instruction required proof of reputational harm. So you see this jury is really struggling with this. And then the trial court, after having listened to this, at the end of the plaintiff's case, I, of course, made my motion, and the judge spoke of how incredibly thin, if any proof of reputational harm even existed. And then after reviewing everything that you saw in the briefing from Dr. Swanson and reviewing what had happened over those 3 days, the judge looked at that record and said there was no proof of reputational harm.
Well,
Counsel, let me ask you this. It seems to me at that point, the judge became the 13th juror and said, I'm going to reweigh this evidence, and it's not enough.
So, Your Honor, I'm going to take issue with the characterization as Judge Hauber having weighed the evidence. What the judge did is he observed whether there was evidence presented and concluded that there was not evidence presented of reputational harm. And in fact, this is exactly
in that process, did he not say, well, this is evidence of it and this is not? Isn't that weighing of evidence? When you say, well, this proves it and this doesn't prove it, that's weighing the evidence, isn't it?
Well, Your Honor, if you look at Gobin, it requires the court to do that, and it requires this court to do that, because Gobin specifically divides categories of evidence of damage into evidence of damage of reputational harm on the one hand, and then what it called evidence of damage, parasitic damage. And the law will not allow evidence of parasitic damage. I spent the time trying to get the deal with the defamatory statement, or I was emotionally troubled by it. All of this types of evidence to which Dr. Swanson points. Gobin divides that, specifically says that's parasitic. It does not count for proof to reputational harm. So the trial court was required to do that type of accounting to which you're pointing. In fact, what the trial court noted was...
Going off of what my colleague was just asking, is it your position then that this Yelp evidence could never establish reputational harm? That a bad review, an inflammatory review on Yelp that then rearranges the reviews that are observable can never lead to a defamation claim?
Oh, it absolutely could, Your Honor, lead to a defamation claim. And first of all, I want to challenge the court to have a look at the record sites that Dr. Swanson points to. There was no proof of what the Yelp algorithm did or how Yelp functioned. There's just not proof of that. Look at those record sites to see what was said. But Your Honor, absolutely, a negative Yelp review could in fact lead to reputational harm. But this is interesting because this case and the proof in this case shows the importance of actually proving reputational harm. Dr. Swanson called this Miss Neufeld a patient. If Miss Neufeld had testified differently, she could have helped establish reputational harm. If Dr. Swanson had actually called any of the people that he says that he spoke to, by the way, we asked for those names in discovery, they weren't forthcoming. They never came to trial to testify. The only one we can rely on is Miss Neufeld. And what her testimony proves is that a lowered rating on Yelp from 5 to 3.5 did not lower her opinion of Dr. Swanson. So if her
that strikes
testimony
me,
had been, Your Honor,
Counsel, that strikes me that is an argument that could be made to a jury, right? And I'm assuming that you in fact did make that argument
well,
to the jury,
we
but
didn't
the
actually,
jury, counsel, but the jury, for whatever reason, decided that there was sufficient evidence of reputational harm here to support their verdict. So they discounted the argument that you're making and have found that there was sufficient evidence. Why are we not bound by that determination?
it's not an argument, Your Honor. It's what Ms. Neufeld herself said. The record, she was specifically asked, did the reduction in rating from 5 to 3.5 cause your opinion of Dr. Swanson to change? And she said no, that her opinion was unchanged, and that afterwards she continued to go to him as a doctor, and afterwards, in fact, referred other people to him as well. So this isn't, this is what the witness herself said. It's this fact that the judge had to deal with, not an argument about inferences from what she said. Now, had she said, Your Honor, yes, that reduced my opinion. And this is the key distinction between this case and Rock Hill and Moran. In both of those cases, especially Moran, take a look at Moran. In that case, there were 3 different people who had seen the defamatory statement and said that their opinion of the plaintiff was adversely affected, if even marginally. And that's what we have. This record has nothing in there about his reputation being harmed whatsoever.
Well,
in
this case, I mean, the jury obviously had a copy of the Yelp review. That was an exhibit, and they got to review that in the jury room. And it's clearly a vitriolic statement about Dr. Swanson and his professional capacity. Is it reasonable as circumstantial evidence for the jury to conclude that some people must have seen that and been dissuaded from contacting him and considering him as a plastic surgeon? Is that permissible?
No, not under Gobin.
Why not?
If we go there, Your Honor, then we have eliminated, we've gone back to the old defamation per se. And we've rewritten Gobin, we've rewritten Moran, because under that scenario, if claims like that go to the jury and then are even you go through and the jury's allowed to like make that sort of determination, we no longer have proof of reputational harm required under the law. And that is crystal clear that under Kansas law, you have to have proof of reputational harm. I think Gobin said it's the gravamen of a defamation claim. Without it, you don't have defamation. And that's really what Dr. Swanson is asking this court to do. He's asking this court to set aside Gobin, set aside Moran, and rewrite the law of the state. And this is would be a major policy decision. And Your Honor, Judge Atchison, you raised the issue of, is the law in need of a review here? Well, the legislature could certainly do that. Maybe the Supreme Court has a look at it again. But if anything, given the way online works with ratings and the way everything is moved online, if the bar is lowered here, then the court's going to take on a whole major new role, because we're talking about a lot of new cases that will have to go to the jury if you dispense with the requirement of proof of reputational harm.
Well, this case did go to the jury, and the judge didn't like the result.
Well, I would argue, Your Honor, that it's not that the judge didn't like the result. The judge, after having reviewed exactly all of the testimony in the case, concluded that there just had been zero proof of reputational harm. And in fact, proof that his reputation hadn't been harmed. And that's really what, Dr. Swanson testified that after the Yelp review, Other doctors freely referred cases to him. He continues to be asked to speak all over the world. He's published extensively in medical journals. He says he remains a leading authority in the field. His resume went on for pages and pages.
Counsel,
Even
I'm
after this-
interested. I'm interested in your view on the law, on Kansas law. It seems to me you're arguing that you can put into one of these reviews the most malicious lies that you can think of, and you're immune from any defamation as a result of that because of the inability to prove some sort of damages. I mean, really terrible, malicious. You know, under the old law, when we had malice, malicious comments being made, you could proceed because the words were so bad. But you're saying that does not exist today. And so somebody is immune from any defamation from no matter what they put in on these reviews. Is that correct?
The how strident the comments are, how dramatic they may be, if nobody hears them or they have no impact on the person's reputation, you cannot maintain a cause of action for defamation. You're right. Under the old law, you could dispense with proof of harm to reputation if the words were bad enough, but the Supreme Court in Gert specifically got rid of that. And then the Kansas Supreme Court in Gobin, and then multiple court decisions since, has said you've got to have proof of reputational harm.
Counsel, you've got about a minute left.
Well, I thank you, Your Honors, for the time. Another major issue was the inability of Dr. Swanson, and this is also raised by the district court. There are about 40 different negative things about Dr. Swanson online. You know, two articles, scores of negative patient reviews, disciplinary actions by Missouri and Kansas Board of Healing Arts, and 30 medical malpractice lawsuits. And so I asked Dr. Swanson how this reputational harm that he had perceived, he'd speculated about, how he knew it came from this Yelp review as opposed to one of these other 40 things. His response was it was common sense. This is not enough under Kansas law. The common sense rule that exists protects the court system, which already is heavily burdened, from becoming a forum for anyone who takes offense at something that's posted in a social media forum. Thank you.
Thank you, counsel. All right, let's go back to the appellant. Let's see, I think you wanted 3 minutes. Is that correct, counsel?
Yes, Your Honor.
You may begin.
First, I wanted to address one of the statements from counsel on the evidence about the Yelp and the algorithm. It's actually found in volume 4, pages 13 to 14, where that was put into evidence. There are a few things that I would like to address. First of all, I think we're in dangerous waters here when we start ascribing evidentiary intent to closing arguments. The jury in this case was actually instructed in instruction number 4 that statements and arguments of counsel are not evidence, but may help you understand the evidence and apply the law. However, you should disregard any comments of counsel that are not supported by the evidence. The closing argument by trial counsel is very good, and I think that it should be reread in its entire context instead of snippets being brought out. The challenge that trial counsel was, and the jury understood it, that the trial counsel was bringing out in closing statements is how do you determine reputational damage when patient volumes are up and revenues are up? And it's a more of a feeling of what are those damages to your reputation when your Yelp rating goes down and you have to answer questions about whether or not you're a monster and people can refer business to you. So I think we're in very, very dangerous waters, and I don't think it's supported by the law that closing statements have any evidentiary value at all. And we believe that by the judge not only tying to that closing statement, but also, as Judge Hill said, acting as though they're the 13th juror and prescribing motive to the jury when they're asking about, can they just take the review down? That doesn't mean that the jury was also not going to award damages. We don't know that. We weren't in the jury room, and it's improper and it's error for the court to consider those two statements in making their decision.
Well, I think the district court may have been looking at the closing argument as illustrative as opposed to like an admission. And the lawyer for Dr. Swanson, explicitly said, I'm not giving you a dollar amount here. I'm not going to tell you an amount. That's up to you. Okay, and that's certainly a tactical decision. And I don't think that binds him to like a zero verdict or something. But you have a jury coming back with $15,000. Where does that come from? I mean, is there some support in the record for that as opposed to the 900,000 that you had in Rock Hill? Or, why isn't that just a number pulled out of the air that's arbitrary?
Well, that's the challenge on these defamation cases that the U.S. Supreme Court's indicated in Gertz. And that is the province of the jury is to quantify that damage instead of, the question is, were there damages? Okay, there are damages. There was evidence of damages. It's up to the jury to determine the amount. In this case, they came back with $15,000 as opposed to the $940,000. The $15,000, I'm not sure where exactly that came from. There was an initial demand letter that was in evidence that they asked for $25,000. And so the jury may have said, well, it's not worth 25, maybe it's worth 15, but that's the role of the jury.
Counsel, your time has expired. If you'd like to sum up.
I'd like to sum up also to briefly address a couple issues. Number one, evidence of parasitic evidence, that's not time spent. That's mental anguish, pain, and suffering, which Dr. Swanson was not claiming. And also the law in the state of Kansas and the United States Supreme Court from Getz, that doesn't apply to when there's malice present. I would recommend that the court look very closely at Rock Hill, Moran, Gobin, and the United States Supreme Court decision in Getz and read that, as the concurrence opinion and the dissent opinion said, they said, as long as there is a reckless disregard, then Getz doesn't apply on the Sullivan versus New York Times malice statement. So we believe that the law in the state of Kansas hasn't been sufficiently developed on when there is malice associated with a defamatory statement. These other cases haven't considered that, and this court would have the opportunity to do so, that when malice is present, damages could be presumed, and we don't believe that's a closed issue under the existing precedent.
Thank you, counsel. We appreciate your arguments. A very interesting case. We will take the matter under advisement and issue a written decision in due